What components make up an effective trust? Attorney Kellen Bryant explains. There are two main components of an effective trust. There is the actual written document, and then there is the funding of the trust. The written trust document is signed by the trust creator, also known as the grantor, and names someone as trustee to be in charge of the trust. That person makes money management decisions, manages the assets of the trust, and makes distributions. In some circumstances, if you are creating the trust, you can also be named as trustee. It just depends on what you are looking to accomplish and what benefit you are looking to obtain. In the trust document, you name the beneficiary. Depending on what kind of benefit you are looking to derive from this document, you could name yourself as beneficiary. You may decide you do not want to be the beneficiary, and you can also state the time at which certain people become beneficiaries. You may have a beneficiary during your life, which would be you, and then you can have a beneficiary upon your death, which would be whomever you would like. The written document should set forth and resolve a lot of common issues that could come up when administering a trust during your incapacity, your wellness, and your death. The language of the trust will generally dictate such things as the timing of the control of the assets, which relates to the timing of distributions, availability of distributions, when a distribution can be given to a beneficiary, when particular trust assets can be sold, what kind of authorization process is required in order to take any kind of action, like a sale or distribution, how the terms of the trust can be changed, how the trustee can be removed or fired, etc. Now that you have created this written document governing management of your assets, your work is not complete. The written document may have required hours of thought and special attention, but it is completely useless unless you perform the second step. The second step and essential component is to fund the trust. Funding a trust means that you are changing the names on your accounts and assets and real estate and so forth to reflect new ownership in the name of the trust. Without changing ownership of the assets, your trust has no legal effect during your lifetime. Depending on the wording of your will, it could have legal effects at death, but in some cases, if the trust is improperly funded and the will is improperly created, the trust is completely worthless and a useless piece of paper. Put your mind at ease and make an appointment to meet with the Berg Bryant Elder Law Group in Jacksonville, Florida today.